Case number 112911, in the matter of the appeal of BHCMC LLC and DBA Boot Hill Casino and Resort.
Last time I was here, I didn't need these. To please the court, Michael Hale, Kansas Department of Revenue. I would like to reserve 5 minutes for rebuttal.
5 minutes is granted.
Thank you. A brief 60-second summation of the procedural history of how this case arrived before you today. In February and March of 2012, BHCMC, otherwise known as Boot Hill, filed certain refund applications with the Kansas Department of Revenue on equipment and games that it purchased for its casino operations in Kansas. The Department of Revenue denied those refund requests. Boot Hill sought a written determination from the department. That written determination was issued denying the refund request for the sales and compensating taxes. Boot Hill appealed to the Kansas Board of Tax Appeals, who, after a hearing, issued its order reversing the department's determination and granting the refund of the sales and compensating taxes to Boot Hill. The Department of Revenue then appealed to the Court of Appeals. Court of Appeals affirmed, and we sought a petition for review here, which you granted, bringing us here today. The question in this case is whether Boot Hill exercised any taxable right or power over the tangible personal property at issue here, incident to the ownership of that property. We assert that they did. Both sides stipulate that the lottery owns the equipment in question. And the record on appeal tells us as much. The Kansas Expanded Lottery Act requires that managers like Boot Hill purchase the equipment and games, and Attorney General Opinion 2009-23 confirms the Kansas Lottery cannot buy the equipment and games such as present here. As a side note, the Attorney General was also asked if lottery could buy the equipment and games, would those purchases be exempt from sales tax? Now, the Attorney General found that in order to be exempt from sales tax, purchases would have to be made directly by lottery. But because lottery was prohibited from making the direct purchases, didn't have to answer that question, inference being, of course, no tax exemption. And finally, the contract between Boot Hill and lottery also states that Boot Hill buys, lottery owns, and that's all in the record. And the facts mirror that. Boot Hill did, in fact, purchase all of the equipment and games that are at issue here today. Invoices from the vendors were billed to Boot Hill, paid for by Boot Hill on its checks. There were no bills sent to lottery by any of these vendors.
But the contract provided that Boot Hill purchased on behalf of the lottery, correct? That's what this wording of the contract, I think.
Well, that's a construct that I believe that Boot Hill put together, but...
Well, both parties, lottery and Boot Hill, signed the contract. That's what it provides.
But when you look at the invoicing, no invoices were ever sent to lottery.
I understand that.
Yeah.
Counsel, I'd like to talk to you first about standard of review. There are a couple of places in the briefing that's occurred both in the Court of Appeals and to this court that indicate that the position of the Kansas Department of Revenue is that we should construe the statutes at issue here basically in favor of the department rather than the taxpayer, because it's a refund provision. That's the position taken in the briefs. Are you continuing to advance that position at this point?
I think when you step back and look at the case as a whole, Boot Hill is trying to, for lack of a better word, shoehorn in under lottery status as a state agency under 3679-3606B, exempt purchases by a state entity. And so, yes, we would say that you would need to construe that fairly narrowly in favor of the department.
That's some kind of 30,000-foot view. They've not cited that statute as a reason that they're exempt, have they?
No, they're claiming that they don't use it, that lottery,
Right.
Lottery uses it and owns it. And therefore, since the state is, quote, the owner.
Right. They're depending upon the definition of use.
Yes.
Correct?
Yes.
And that definition includes that the user of the equipment in question has to display or make use of incidents of ownership. Is that right? That's really what this case comes down to, is
Yes.
whether they are exercising incidents of ownership.
Yes.
And they're relying on our old GM case to say that they are not. Is the department advocating that GM be overruled?
No.
Okay, you're saying it's distinguishable,
Yes.
and that's all that you're relying upon. You're not
Correct.
suggesting that its ruling on incidents of ownership and what that means needs to be overruled on the way there.
That's correct.
Okay, thank you.
As we pointed out, there's no evidence that any bills were sent to lottery by these vendors, and there's no checks from lottery to the vendors. Yet somehow lottery owns this equipment. What the record does not show is how did this property move from Boot Hill to lottery? Boot Hill never showed how that happened. And I think it's readily discernible how lottery came to own this property. Now we know how they did not own it. They didn't buy it. There's no sale here. KELA prohibits it. And the Attorney General opinion confirms that. So we can cross that off our list. And that only leaves one other way that this property could have moved from Boot Hill to lottery. Boot Hill transferred its ownership of this property to lottery as part of their contribution to this joint venture called a casino.
On that point, Council, the contract specifically says in paragraph 74 that no joint venture is being created, does it not?
Yes, in a pure sense, that's correct. But when you look at, again, the contract as a whole, they are together. It's a unique relationship. They are operating together because Boot Hill manages this casino. It's not a strict legal joint venture, and forgive me if I use that term in a legal sense. I meant they are working together to operate this casino. But Boot Hill's transfer of that property, its ownership of that property to lottery, is an exercise of its right and power over that property incident to its ownership. It's just that plain and simple. Boot Hill bought the equipment and games, and for a period of time, no matter how small it was, they owned it. Then they transferred it to lottery, fulfillment of its part of this agreement to run and operate this casino. And when you own something and then you transfer it, that's an incident of ownership. That's what we have here.
So
Count-
are you saying, excuse me, Chief, are you saying that the Boot Hill bought and owned the property until it was physically placed on the gaming floor, at which time then the contract made it the lottery's property? Is that your argument?
In essence, yes.
So for Boot Hill to avoid this problem in the future, they would have to put something in their contract that says if we get dinged by the Department of Revenue for this tax, then we need to be reimbursed. Is that how they protect themselves?
I don't know that they can, Justice Nuss, because here's the problem. And this is what distinguishes this case, Justice Breyer, from General Motors. When you look at the General Motors case, in paragraph 6 of the facts that was cited in General Motors, the court noted that, and I would quote, the United States made reimbursement to General Motors, quote, promptly on receipt of General Motors voucher therefore, end quote. We don't have that here. Boot Hill never presented any invoice or voucher to Kansas Lottery for reimbursement. And you know why? Because that would be a sale to lottery. What prevents that? Keela.
Let's
Lottery
back up.
cannot buy it.
Can we
Well,
back
this-
up to the purchase of the machines? What do we know factually about when ownership vested? Was it on delivery of those machines to the casino?
I believe it was the way that, I do not recall precisely, Justice Hooker, but I believe that Boot Hill was required to have the insurance there in place at the time they were shipped. So it would be, I believe, from the moment in time of purchase, shipment from places like Aristocrat and Bally to Boot Hill. That's when it would have occurred.
So it's during that period of shipping that you're arguing
On its way to-
ownership was with Boot Hill.
Yes, on its way to Kansas. They were required to keep the insurance in place there. Boot Hill bore the cost of loss. And that's another distinguishing factor in the GM case that we point out in our brief.
And to go back to my point, it's just the cost of Boot Hill's doing business. They're going to be having to pay this use tax.
Yes,
As a matter of law, there's no way to avoid it.
that's correct. And Boot Hill makes the argument that they were reimbursed, as we pointed out. My time's up. I'll address it later.
Counsel,
Proceed. You can finish your statement, then Justice Stiegel has a
Thank you.
question.
Okay. Boot Hill argues that they were reimbursed just like in General Motors. There's no evidence in the record tying to specific payments for this equipment and games from this pot of generic gaming revenues that they receive downstream at a much later date for these specific invoices. This is not like the GM case where the U.S. government wrote a specific check. Justice Stiegel?
it sounds to me like your argument to us here this morning is that the incidents of ownership occurred, in your words, in however short a period of time between the purchase and the, as Justice Johnson said, the putting them on the floor. Is that right?
I'm sorry.
You're not arguing that the use of these machines in the casino is an incident of ownership anymore. It sounded like you're limiting those incidents to that period of time before the transfer took place, in your words. Is that right?
I think that it's a continuum, Your Honor. I think the first
Well,
incidence of ownership was the purchase. The second was the transfer from Boot Hill to Lottery, and we also have a litany of other incidents
well,
of ownership.
let me ask you about that. Once the transfer occurs, again, I'm using your language, do you think that there are any uses that are incident to ownership after that transfer?
Yes, and we point that out in our brief. I don't know how much latitude I have to continue to answer.
Keep
with my
answering
time.
his question, it's
Okay.
fine.
We point those out in our brief.
That's what I was confused by. I just couldn't tell if you were
We're not
altering your
abandoning
position.
those. We're saying these attributes of the ownership, not its ownership, but the ownership interest, and that's what the statute says, the ownership.
And that's consistent with the position the department took all along, because in
Yes.
fact, you assessed these taxes for over a period of many years,
Yes,
right?
yes.
So you weren't relying on this argument about, well, they owned it for a however brief period of time, and that was an incident of ownership, the transfer itself.
Right, the incidence of ownership is continuous here, and we point those out. Keeping it clean and playable for the patrons, the insurance, the repairing, having technicians to do the repairs, it's all a continuum for part of the operation of the casino.
And the bottom line is that the ownership, the actual titled ownership, can be in a third party, and it doesn't make any difference under your view of the law. The statute's plain language says incidents of ownership, and what matters are the incidents.
Yes, because the tax has already attached, and because ownership may transfer later is irrelevant, because the tax had already attached to Boot Hill, and they can't slough it off at a later time by some kind of theory of reimbursement or what have you.
How do you answer or get around that the Kansas Expanded Lottery Act really was designed and intended to allow, and explicitly states that it places full and complete and ultimate ownership and operational control in the hands of the state. I mean, that was what the kind of bargain for exchange was in order to make this constitutional in the first place. So just given that broad understanding of what KELA just is and how it got to be constitutional in the first place, that's what we hinged it on. How do you carve out this little exception, or pretty big exception here, for ownership? Because that isn't what it was designed or contemplated to be.
We view this as a straight up tax case. KELA is, for lack of a better term or phraseology, KELA is kind of trying to be used as a shield to avoid taxation here, but this is really a straight up tax case.
Well, let's talk about that. This is a compensating tax.
Yes.
Not a sales tax. The sales tax would be payable upon purchase.
Yes.
But
And so-
compensating tax, if you buy something in Oklahoma, you don't owe the compensating tax until you put it to use in Kansas, correct?
Yes.
Okay, so the thing I don't understand is when it's put to use in Kansas is when it's put on the gaming floor. If it stayed on the truck and went to Nebraska, you wouldn't own compensating tax, would you?
No.
And so the tax isn't due until it's put into use, and by contract, when it is put into use, it's the lottery's property.
Under the Compensating Tax Act, an incidence of use, if I purchase something and I own it, and let's say I purchase something from out of state for my son's birthday. He played baseball. I bought him a $300 baseball bat from out of state. I paid the compensating tax on it. Then I gave him that baseball bat. I've transferred my ownership to him. I never used that baseball bat because I was never a good ball player. He was. I owed that tax, even though transfer was immediate.
And what triggered the compensating tax? The fact that you were a Kansas resident, or
My transfer of the ownership, I had the ownership, my transfer of that to him. I exercised that ownership right and power to him by transferring
By
it to
making a
him.
transfer. The transfer is one of the incidents of
Yes,
ownership,
yes,
in your view.
Yes, you have to exercise that power and right.
Is there any,
Possession, use, transfer, exclusion. Those are the incidents.
is there anything in the record that would indicate which portion of the taxes occurred prior to this transfer? Or were assessed prior to the transfer? In other words, it just seems to me like you're
Some of the
presenting a legal argument that doesn't fit with what the department did below.
Some of the taxes were paid as a sales tax and under protest, and some were self-assessed as a compensating
But the
tax.
department, correct me if I'm wrong, but is there anything in the record that demonstrates that the department said, look, prior to this transfer, you owned it, and this is the compensating use tax for that period of time?
I don't believe the
Because
department.
the department never looked at this case in that way before, did it?
No, we've always looked at this in the broad spectrum of the incidence of the tax and use, and the transfer is simply one indicia of ownership. You have lots of multitude or a plethora of opportunities to use your property the way you see fit, and this is one of those.
So you're saying other incidents were being exercised after that?
Sure, and we point those out in our brief as well. Thank you.
Just so I'm clear, counsel, you're saying that for these casinos to exist, the state is not going to be paying a tax, and it has to come therefore from the operator of the casino. There is no third alternative, which is nobody pays a tax.
That,
that right?
I believe that's correct, Justice Nelson. I think the legislature set it up that way purposefully. The legislature set these casinos up so that, because they didn't want taxpayer money to be fronting all of this money, millions and millions of dollars for all this equipment. Instead, they said, we're going to give you a 73% cut, 15-year no-compete zone, but you put your money, Boot Hill, on the line by making the purchases. And we're going to own these games. You're going to transfer them to us, basically, so we can monitor and keep everything kosher. That's purposeful. And there's no out for lottery to buy this, and the Attorney General opinion points that out. And the only direct purchases are exempt from any kind of tax.
Thank you. Any further questions? No. Thank you, counsel.
May it please the court. My name is Matthew Lamoli. I'm here today on behalf of BHC MC LLC, who I'll refer to as BHC or Boot Hill. And I'm going to begin by addressing the Department of Revenue's argument they made today. As some of the justices have pointed out, it's quite a different argument than the argument they've previously made.
Can we start with something simple?
Sure.
First of all, you have a different view of how we review these statutes.
Correct, Your Honor.
With the benefit going to the narrow construction going in favor of the taxpayer.
Mm-hmm.
And that's because we're looking at a taxing provision, not a refund provision. Is that right?
That is correct, Your Honor. This case involves the construction of KSA 793703, which is the statute that imposes the use tax.
Right, and the definitional section in 3702C, right?
Correct. Correct,
Okay.
Your Honor.
And I asked your opponent whether we needed to overrule GM to rule in his favor. He said, no, GM's distinguishable. I understand that it's your position that GM is not distinguishable, but let me ask you something a little bit different. If we decide that he's right about the plain language of 3702C, and that the ownership does not need to be held, the legal ownership, the title, does not need to be in the hands of the user. It can be a third party's ownership, such as, in this case, the lotteries. If we decide that, is there still a way for you to win this case?
Absolutely, Your Honor.
Can you explain that to me, please?
Yes, because what 3703 taxes is not the purchase, and it's not ownership in the sense of holding title, but it's just as the statute says, it's use, defined as exercising a right or power that is incident to ownership of the property. And ownership in incident to ownership may not in all circumstances involve holding title. But for those words to be given meaning, for those words to be interpreted according to their plain meaning and not made superfluous, then there needs to be some exercise of right or power that is common incident to ownership. Incident to ownership would be defined using the Black's definition of incident as a right that's consequential to ownership, dependent on ownership, arising from ownership.
Right, and that is further described in Black's as some of the things we just listed. The power to possess,
Mm-hmm.
the power to use, the power to transfer, the power to exclude others from using.
Mm-hmm.
In your view, Boot Hill doesn't have any of those?
Boot Hill has none of those rights because Boot Hill does not, to elaborate, to look at, for example, how the Court of Appeals distinguished the circumstances here from a lease circumstance, whereas a lease, the use that a lessee exercises will generally fall within the use tax, but a lessee has a great degree of control over the property they lease. You lease a car, for example, and you can drive it wherever you like. You can make minor modifications to it. You can, in some cases, sublease or sublet it to somebody else. Boot Hill can do absolutely none of those things. It cannot transfer or convey any right within the EGMs to any other party. It cannot even move the EGMs from one spot on the gaming floor to another spot on the gaming floor. Can't add them to the gaming floor, can't remove them from the gaming floor without the express consent and approval of the Kansas Lottery, who is the true right holder, the true power holder. So the type of duties that Boot Hill has with respect to the EGMs, the legal duties, the contractual duties, those are not rights or powers over the property the way that an owner has, or the way that somebody who has an interest akin to ownership, such as a leaseholder, has over property.
But Boot Hill controls who uses those machines, right?
By who uses, in this sense, are you meaning the patrons who play games on the machines? No, I wouldn't say that Boot Hill controls who uses those. Boot Hill manages the casino, and it provides security for the casino. But the user, in the sense of exercising a right of control, a power of the machines, that's always the Kansas Lottery in all cases.
Does Boot Hill do anything with these machines once they're installed on the gaming floor? Reference was made to maintenance and repair, I believe.
Yes, it has certain duties to repair the machines, make them suitable for patrons to come into the casino and play them. And what I would analogize that to, Your Honor, is a service contract that I might buy for some property I own. For example, I have an air conditioning unit at my house. I could buy a service contract for that air conditioning unit, and that would give the person on the other end of the contract a duty to repair my air conditioner if it breaks down. But the person who I contract with would not be responsible for use tax on my air conditioner. He wouldn't have what we would call a right or power incident to ownership over the air conditioner. He doesn't really have any rights at all. He has duties, a contractual duty to come to my house and repair my air conditioner if it breaks down. And that's exactly the same type of duty as opposed to right that BHC has with respect to the EGMs. So to address the argument that the Department of Revenue raised, the argument that BHC bought the EGMs and then transferred their ownership to the lottery, there's a few problems with that argument. The first one being that the department never raised that argument in their briefing below. So we'd first take the position that that argument has been waived. The second problem with that argument is that there's nothing in the record to support it. There's certainly no type of document that would show any transfer of ownership from BHC to the lottery. There's certainly no document that would show BHC ever took an ownership interest in the EGMs. But what is in the record shows that the opposite occurred. Shows that from the moment the EGMs were purchased, their ownership interest was within the Kansas Lottery. I'll direct the court to page 55 of the record, which is a sales and security agreement that BHC and the Kansas Lottery executed with Bally, who is a manufacturer of electronic gaming machines. It's a sales and security agreement that defines the Kansas Lottery on behalf of the state of Kansas as the owner-operator of the machines that are subject to the contract. And in paragraph 3, caption delivery, it states, Bally shall deliver the equipment to a common carrier for transportation to owner-operator. Again, that being defined as the Kansas Lottery on behalf of the state of Kansas. Delivered to their place of business. Further down in the paragraph, it says, owner-operator, the Kansas Lottery, shall take delivery of the equipment within 30 days after Bally completes manufacturing of the equipment. So it was the Kansas Lottery who purchased, who took ownership of the EGMs from the date the contract was signed. It was the Kansas Lottery that took delivery of the machines. There was never any point at which BHC took an ownership interest in the machines. And in fact, if they did so, that would be contrary to their contractual obligations to the Kansas Lottery. Paragraph 21 of the management contract, this is page 675 in the record. states, manager, that being BHC, has no authority under this agreement to own, purchase, or lease any lottery facility games except on behalf of the state of Kansas and through the Kansas Lottery. And there's been no allegation whatsoever that Boot Hill is in breach of that contract provision. There's no evidence to suggest it in the record, and that's because it didn't happen. Boot Hill has never breached its contract with
Who
Kansas.
paid for the machines?
BHC did pay for the machines. But as has been discussed, the use tax does not tax the purchase. The taxable incident is the exercise of power or right over the property. So to cover some other things that have been discussed, I believe one of the justices mentioned earlier this court's decision in the State XRL 6 case, where the court upheld the constitutionality of the Expanded Lottery Act. The issue before the court in that case was whether the Expanded Lottery Act and its provision for lottery gaming facilities, as Boot Hill is one of those, whether it complied with the constitutional mandate that any lottery in Kansas be owned and operated by the state. What the court found was that it did comply with the Constitution. It found direct statements of ownership and operational control by the state are not mere verbal camouflage. It found rather that the Expanded Lottery Act places ownership and control of key lottery elements, and that would certainly include the EGMs at issue here, squarely in the hands of the Kansas Lottery.
If we rule in favor or adopt the interpretation of the use tax statutes that are urged on us by the Department of Revenue, do we run into a constitutional problem on the back end?
We certainly believe so, Your Honor, because...
In other words, the KELA itself might be, at least arguably, the more incidents of ownership that appear to belong to the casino managers, there's a potential that we run afoul of our constitutional prohibition of that.
I think there would be an extremely strong argument, Your Honor, that the entirety of KELA would then be unconstitutional. Because if the court is going to find that Boot Hill exercises a right or power incident to ownership, arising from ownership, a consequential part of ownership, if the court finds that BHC has that type of power over the EGMs, then we're no longer looking at a state-owned, state-operated lottery. We would be looking at a lottery in which a private party, BHC, has a significant amount of power or control over a key lottery gaming element. So I think it would be rather ironic if the Department of Revenue, in its attempt to collect use tax on these EGMs, ends up invalidating with a decision that would invalidate the entirety of the Expanded Lottery Act, and in the long run would deprive the state of far more revenue than what is at issue here with the use tax.
Is it your position your client is basically just an agent of the lottery?
It's a relationship that's comparable to an agency relationship. I believe it was, as we cite in our brief, it was described by the executive director of the Kansas Lottery as an agency relationship. It's essentially a relationship where BHC uses its expertise in managing casinos to help the state manage the Boot Hill Casino to produce the maximum amount of revenue possible for the state. But under the KELA, under the administrative regulations, under 112, 107, and under the contract with the state, all final control over how the games are run, over what games are purchased, over what games are put on the lottery floor, over what prizes are available to the patrons, all those decisions are made by the Kansas Lottery.
But for the things that are within your control and authority, are you saying that your client is an agent of the state?
Well, there's really, as far as the EGMs are concerned at least, there isn't really anything that our client has direct control over. Essentially, Boot Hill can make recommendations to the Kansas Lottery about, well, these EGMs should be added to the floor, removed from the floor, but the Kansas Lottery has not only veto power, but it has to give the approval in the first instance before BHC can do anything with respect to the EGMs.
But you bought the machines.
We paid for the machines, correct?
So were you acting as an agent for the state at that time? Is that your
As
position?
a purchasing agent.
The contract provides that you do it on behalf of the lottery, does it not?
Right, on behalf of the lottery for the state of Kansas, those words can be construed to create an agency relationship. But I think it's important to point out that the decision as to which games were purchased, who they were purchased from, that was made by the executive director in consultation with BHC. BHC did not decide that on their own either. And I believe I've discussed everything I plan to discuss unless there are more questions from the board.
Any more questions of council?
Do you care anymore whether you are the owner or not? That was really what all the briefs focused on until we got here today, was are we an owner or not an owner? And we're not an owner, therefore we can't have the incidence of ownership.
Right,
We now
well-
see that really it's about the incidence, not about the ownership necessarily under the plain language of the statute.
Well, sure, it's about both. I mean, I think for one, Your Honor, actual ownership, whether it's partial ownership or holding the title, that is a very important fact in determining whether incidents to ownership exist. So here it's undisputed there is no ownership. That would be prohibited by KELA, by the management contract, by the Kansas Constitution. But here, if you look at whether there are incidents to ownership without strict ownership, there's also not that either, because it's the Kansas Lottery that makes all decisions concerning the EGMs, that exercises the power and control over the EGMs.
Any more questions? Thank you, council.
Thank you, Your Honors.
Just two or three real brief points, if I may. As we discussed in our petition for review, the Supreme Court of Rhode Island in WMS Gaming and Great Lakes Dredge and Dock discussed in pretty nice detail the interplay of concurrent users of property within the scope and context of taxable use. And as part of its analysis, the Rhode Island Supreme Court determined that taxable use can be found even when one has little power or control or right over the property, when another exercises substantial degree of power or right. But here, Boot Hill didn't just exercise any right or power. As our record shows, Boot Hill's use of this property, from its purchase to its transfer to lottery to its continuing use of the incidents of ownership in cleaning, insuring, repairing, having techs on staff, etc., qualifies as a substantial exercise of right or power over that property.
Counsel, are you not concerned at all that the position that you're advocating undermines the rationale of XREL 6 and potentially undermines the constitutionality of KELA itself?
No, not at all.
Why not?
Justice Siegel. Well, because I think, again, Rhode Island Supreme Court addressed that head on. And I think the logic there applies equally here. The incidents of right and power necessary to establish a taxable use are far different from the ownership assigned that's far different.
The sixth case relied on what might be characterized as a legal fiction, i.e. that the state is the owner of the lottery. But the more incidents of ownership that you transfer away from the state, I mean, aren't we moving perhaps from a legal fiction to sort of the realm of fantasy? At some point, the state can't give away all its incidents of ownership and still claim to be owning and operating the casino, can it?
Well, respectfully, Justice Siegel, the ownership actually flowed into the state here. By Boot Hill's own argument, the facts in the record, lottery owns this equipment. Oh, the ultimate ownership eventually resides with lottery. That's indisputed, or undisputed, rather, excuse me, undisputed. The question becomes, who exercised?
So for purposes of the Constitution, the constitutionality of KELA, the state can own.
We're
But for
good.
purposes of taxation, the state can discharge itself of essentially all the essential incidents of ownership.
Because the tax had already attached to Boot Hill. The incidence of tax had already attached, and Boot Hill cannot slough it off at a later period of time by some kind of theory of reimbursement later on down the road that they tried to come up with. This is not like GM, where a voucher was presented for this equipment. You know, Boot Hill's arguing, well, you know, we make this investment, we're reimbursed later on, etc. The Court of Appeals bought off on that. And that's too thin of an argument. This court
Well,
shouldn't buy
what
off.
evidence do you have that Boot Hill exercised ownership? The contract says that the state of Kansas and Kansas Lottery is the owner. It was bought initially as the state as the owner. When is it that Boot Hill exercised ownership, and where is it in the record?
Well, I'm looking at the sales and security agreement between Boot Hill and BH Development and Aristocrat, for example, but I don't see Kansas Lottery's signature here. When you look at
But
the
is the lottery's name on there?
it says Kansas Lottery on behalf of the state of Kansas as owner-operator, but then when you look at the guts of the agreement, there's no Kansas Lottery in here. It just says BHCMC LLC manager. When you look at the Valley, again, on the signature blocks, I don't see a lottery's official signature. And you look at the guts of the document,
But do you agree that they're all of the purchases are made in the name of the lottery?
I agree that Kansas Lottery on behalf of the state of Kansas appears on the document, but it looks like Clark Stewart is the one who's signing.
And do you agree that the decision on which equipment to purchase and from whom to purchase it is made by the Kansas Lottery?
Yes. But the purchase was still made by Boot Hill. The invoices were to Boot Hill. They paid for it. They made the transfer of the property to Lottery. That's the first incidence of tax, and the incidence continued on through the continuous use by Boot Hill.
Forgive me, but I thought we established earlier that the purchase outside the state is not the taxable event. It's once the equipment's in the state being used, that's the taxable event under the provision you're invoking here.
And the transfer, in our opinion, the transfer came in Kansas to Lottery.
I understand that, but you said the purchase started the taxable event, and you didn't mean that, because earlier you said that wasn't a taxable event. You agreed with my colleague, Justice Johnson.
I'm trying to show an entire flow that Boot Hill's hands were here all the way
I'm
from.
correct that you told him that
Yes.
earlier? Okay, thank you.
Kind of curious, is there a way for an operator to break this down in so many segments so there's only one incident of ownership for each? For example, an entity is created to sign a contract saying, on behalf of the state of Kansas, we're buying this equipment. Another entity is created to take the next step. We're now signing the shipping document on behalf of the state. There's another entity created to say we're not accepting delivery, another entity. Or tell me why that does work or does not work.
Well, Justice Nuss, I think that's chillingly prescient. The way the Court of Appeals decision has been created, because there are 50 plus some odd exempt entities within the Sales Tax Act. The way the Court of Appeals decision currently stands, you could have a meld of private and exempt entity, for lack of a better term, partnership, where private enterprise could go to these exempt entities, for example, a nonprofit hospital, doctor's group, say, look, we can set up this LLC. We'll do it in the hospital's name. We'll buy all this equipment as a doctor's group. We'll say it's for your purpose, using the magic words out of GM to accomplish their purpose. We'll use the equipment. We'll revenue share, but we'll have ownership in you. All that equipment that would normally be taxable because the doctor's group bought it now becomes exempt. And I could go on and on with the parade of horribles that this could happen, but millions of dollars would go through tax-free. And isn't it ironic that the legislature set up these casinos to generate revenue, and one of the first cases of taxes that comes along to discuss this could ultimately end up costing the state millions of dollars, just as the very thing you pointed out, Justice Nuss. That would be an unintended consequence if the Court of Appeals decision is allowed to stand. And we would ask respectfully the Court of Appeals be reversed and the refund claim be denied here. Thank you.
Any further questions? All right, thank you, counsel. We appreciate the arguments from both of you this morning. The court will take this matter under advisement.